Number one, we need to rethink the entire litigation system under Article 2. Because under Article 2, everyone is made a private solicitor general. That basically means the court's enforcement jurisdiction is not just original, but it is also epistolic. If it is epistolic, that is, if it is open to the ordinary man, then the court needs to move away from the traditional model of litigation, which is pregnant with technicalities, and focus more on reducing the burden on the individual who seeks to enforce the Constitution. A good example of that is in the United States case of Gideon versus Wainwright, where the plaintiff, Gideon, wrote his writ to the Supreme Court in jail, in pencil, on jail letterhead. The Constitution, the US Supreme Court just set aside all the technicalities and accepted the writ, heard the case, and Gideon versus Wainwright is why criminal accused persons have the right to counsel in the United States today. Another example of a country that has perfected this is India, where basically the Supreme Court allows ordinary people to write a letter to them, and in that letter, express any frustrations that they have with the Constitution in terms of their rights being trampled upon, and so on, and the Supreme Court pronounces on that. This concept is not entirely new in the Ghanaian jurisprudential space, because if you look at Luke Mensah of Sunyani versus Attorney General, and I'd like to read what Justice Akwa said. We are convinced that as the highest court of the land, charged with the constitutional authority to interpret and enforce the Constitution, and thereby promote rule of law in our society,